Good morning. You are Ronald Bratton. And Mr. Bratton, you were previously in court and entered a plea of guilty to failure to comply with sex offender registration requirements. It was an open plea to the court. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Are there any additions or corrections?
Not so much, Judge.
All right, Mr. Kelly, you may proceed.
Judge, one of the conversations that Mr. Bratton and I have had over the last couple of weeks, and certainly while this case was pending, is that everything that you've got in front of you was not going to be a surprise. We knew what our background here was. One of the things, two really in this case that I've never seen before. One, you can see Detective Flores' statement here, and while he may not necessarily be advocating for probation, he is at least mentioning it as a possibility, and that's because, as he should be, Mr. Bratton is in compliance right now and has been since after the indictment and after the arrest. The other reason for that is because they have, maybe limited, but they have interactions with each other because he's required to check in with him and stay in touch with him as part of his registration. The other is, and this is from Mr. Bratton's perspective, I've never had someone come to me and ask me to ask the court for safety. I know that it happens, but I'm saying it's never happened to me because it's that rare. And the reason that is one of the things that we're asking the court for today is clearly there are other charges in here where he hasn't registered. It's the same thing we're dealing with now. We understand that. We're kind of owning that as best we're able to right now. But everything that the court's looking at, including the registration issues, it's all drug related. All of it's drug related. Ronald has an issue. He wants to get serious help, I think for the first time, addressing it. And finally, Judge, we talked about this morning, and he and I have talked about it over the last week or so, and we don't say it casually, we say it because it's true, because it's coming from him and his experience. It's one thing to be sentenced to TDC, and we're very aware that the court has all the authority to do that today. But the way that he said it to me is, it would be very easy to go do something I've already done and sit and count time. Not that there aren't other things that he can do to improve himself, but sitting and counting time is not hard. Yeah. Doing probation with some pretty serious restrictions on it is hard. It's at least harder than that, as he's conveyed it to me. We have asked while this case has been pending a number of different times, at least 2 or 3, for permission to leave the county to go work for a weekend or work some odd jobs because, frankly, he's scraping it together right now to get to the next day to try to make a living.
Pause for a second. Notice what the defense is doing here. They're not just asking for leniency, they're framing it as rehabilitation over punishment. That's community supervision in legal terms. Basically probation with strings attached. Smart move, but will it sway the judge?
Try to improve on some things. We're asking the court for community supervision. We're asking the court, if it grants that, to add on any conditions that the court believes are necessary. I'd also like a chance to allocute for the court if you'd allow me to.
Go ahead. Oh, I'm sorry. Go ahead, sir.
How you doing today? I'm a little nervous because, I'm sitting in front of the judge. I've been through this since I was 18. Got arrested at 18, indicted at 19, and been going through it. And I've been having that jacket on my back.
Whoa. This is one of those moments where raw vulnerability collides with cold procedure. He admits his past mistakes, talks about becoming a father, but in court, emotional appeals are a gamble. Do you think personal growth outweighs a record stacked against him?
And also a drug addiction problem. And I've been running like a little boy, just getting by life. Well, since the last time I was at this court, I'm a pawpaw now. And changed me more than even having a kid. You know what I mean? And I'd like to be a better granted than I was a dad.
Mr. Hoffpower?
Your Honor, the state take judicial notice of the PSI, and also in the indictment, you'll see that this defendant has been convicted 3 prior times for failure to register as a sex offender. That's included in the PSI on page, you'll see on page 4, you'll see that it is Grayson County, Hardin County.
And here comes the prosecution with the hammer. 3 prior convictions for failing to register as a sex offender. That's not just a slip-up, that's a pattern. In legal terms, this crushes any argument that this time will be different.
2 other counties where he was given probation and failed and was revoked, sent to the penitentiary. And then as well as, I mean, this is a problem, obviously, and, you know, he's already been to the pen for this. He's been an opportunity to have probation. He did not complete probation twice. I understand in light of being, you know, those things, but they're always going to be there. And this is a history of not complying with the registration, which he's had that responsibility for a long time. Therefore, we're in here hearing arguments that we hear the first time they do this, not if you'll see there other times have been dismissed. I'm not even talking about that. I'm talking about the times that he was convicted, and that's 3 from other counties, not Jefferson County. So it's hard for me to take that seriously when it's happened before, and that stuff hasn't changed. Nothing changed within that. And yet here we are again. And
Listen to that. On paper, you deserve 25 to life. That's the judge reminding everyone that legally she could throw the book at him. Instead, she acknowledges the plea bargain, reducing it down to a 3rd-degree felony. That's a massive lifeline, but also a warning shot.
Through his explanation is that he just decided he didn't want to do it anymore, and he left. Now, whether or not that drug issue, I can't speak to that, but all we know is what we know, and that he has been convicted of this. He knows he needs to do it, yet he fails to do it. And he's going off, and we don't know, and that's the point of having a failure to register, is that we have someone out there who's shown the propensity to act that way and not comply.
Right.
Oh, so yes.
Thank you, Mr. Hoffpower. For some reason, there it is. Used daily. Okay. I have a big question mark on this one, Mr. Bratton, because on paper, you deserve 25 years to life. You're habitual. The fact that your attorney negotiated a plea just to a 3rd-degree felony is already a huge win, in my opinion, because future behavior is typically, we can tell what you're going to do by what you've been doing in the past. A lot of times people can change, and you've been given so many opportunities. I appreciate Detective Flores's statements. I appreciate the fact that you want help. I don't disagree, honestly, that probation sometimes is harder than prison, especially, if I give you 10, you're probably not going to do half of that, maybe a third of it, and then we don't have anything. Anything as far as being able to really keep track of you and for a longer period of time. So what I'm going to do today, Mr. Bratton, is give you probably the last chance you're going to get, at least here in this county.
0 tolerance. That phrase is courtroom dynamite. Translation: 1 slip, 1 dirty test, 1 missed meeting, and probation ends instantly. Straight to prison for 10 years. No second chances, no excuses. Do you think that level of pressure helps someone change, or just sets them up to fail?
All right. So I am going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. I'm going to sentence you to a term of 10 years in prison, but I'm going to probate that. You will be on probation for 10 years. You will be ordered to enter and successfully complete the SafeP program. You'll go into custody today, you'll wait for a bed, you'll go to SafeP, you'll get out, you'll do whatever aftercare. I would like it probably to be through JCDI, unless there's something else. I want it to be intensive outpatient when you get out. You will be given the tools to be successful. It's up to you to take advantage of that. You will be, from the beginning, on the high-medium caseload, and you will be on 0 tolerance. That means there is no, I relapsed and I tested positive. There is no, I missed a meeting because I couldn't make it. You make one mistake, I want probation to bring the case back in here. You're going to go do the 10 years that I just gave you. It's just that simple. This is it. This is your chance. There will be no room for mistakes on this probation because you've already been given that leeway earlier in other cases. So this is it. If you do everything you're supposed to and you change your life like you say you want to, that's your choice at this point, right? It's addiction is what it is, but you have the choice now to fight that addiction and to overcome it with the tools we're going to give you. And if you don't, you'll be back in here again looking at the 10 years. If you do everything you're supposed to, then you'll be able to serve that 10 years while you're out on probation. And live like the rest of us. Get a real job, be a real dad, be a pawpaw, be all the things you want to be. It's 100% up to you. I will not.
And just when you think the tension's easing, boom, another defendant gets nailed. Testing positive for marijuana while on probation for sexual assault charges. That's not just reckless, it's legally suicidal. Watch how fast the judge's patience evaporates here.
You have a 10-year sentence. There will not be negotiations when you come back for some lesser sentence if you violate. That's part of this. You do have rights to appeal that. You've pled open. I'm going to hand you the trial court certification that shows you do have some limited rights to appeal. You can talk to Mr. Kelly about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kelly. All right, I wish you the best of the luck, sir. You can go back with the bailiff. Thank you, Mr. Hallpower, Mr. Kelly. I'm going to order a $500 fine as well. Is probation still here on? Yeah. So, Mr. Anderson, you tested positive for marijuana. What?
The 20-day custody order is basically a legal timeout. It's the judge buying time, keeping him locked up while figuring out the next move. Think of it as a pressure cooker. No bond, no freedom, and no more wiggle room. The stakes just skyrocketed.
It's been 26 days since I last smoked.
Well, it's ridiculous that you're smoking at all. You're on probation. Hold on, don't talk over me right now because things will go much worse than what they're gonna. You're on probation for sexual assault of a child and indecency with a child by sexual contact. You have done nothing that you're supposed to of the things that really concern me with regard to your treatment, your sex offender treatment, all of those kind of things. In addition to that, you're spending your time smoking marijuana. At this time, I'm going to revoke the bonds in each of your cases. There will be no bonds set at this time. I think that is in the best interest of the community and the safety of everyone. We'll get an attorney appointed immediately, and they'll be out to see you, and we can see if I need probably a motion at this time. Okay? You can go back with the bailiff. I'm sorry?
Do I have the time to speak? Can I speak to you, Lord?
Hold on. Actually, before you do that, he's not on bond.
No.
Okay. So what I'm going to do at this time is I can't do the bond, but I'm putting you in custody. I just got to figure out the right legal way to do it. I'm going to find at this time as a condition of your probation that you serve at least 20 days. That'll give everyone time to get everything taken care of so that we can move forward and see what the appropriate way is. So I'm ordering 20 days as a condition of your probation starting today, no credit for any time, and then we'll see where we get. All right, go back with the bailiff.
No, I think we type it today.
Okay.
Send it over to them.
Perfect, thank you.
Thank you.